Good evening, everyone. Glad that you could join us in this particular session of the webinar put on by the Sustainable Forestry and Land Retention Project here at Roanoke Electric. I'm Alton Perry. I'm the program director, and we're glad and honored to have with us this evening two professionals, legal professionals out of the legal profession to help you navigate through the issues of estate planning and heirs property. Also would like to make sure that at the end of this session, there'll be a short survey that we'll ask you to take about 5 or 6 questions. If you would please take that survey for us so we can gather the information which is important to provide back to our funders and partners. So without further ado, Mavis Craig and Pamela Harrigan Young will have opportunity to go through all of their presentation. So Mavis and Pamela, you can take it away.
Hey everyone, great to be here. So Pamela and I refer to this presentation as Strong Roots, New Growth, and we are going to talk about heirs property and estate planning basics, as Alton mentioned. Thank you in advance for everyone sending in questions. We have received a lot of great questions that we look forward to responding to. We won't be able to answer every question directly. However, I do think based on the questions and the presentation that we prepared, that you will get, a lot of you will get answers to your questions, and then there are some that we can address directly. So a little bit about us. Pamela, you want to share about yourself?
Yes, certainly. Okay. Good evening, everyone, and thank you for the opportunity to present this evening. We're looking forward to sharing what we hope will be helpful information. I am an attorney and a CPA, and I have 2 different practices. My law practice focuses on estate planning and estate administration, as well as heir property and elder law issues. And my CPA firm focuses on tax preparation and tax planning. And I certainly have a passion for preserving wealth through reduced taxation and then transferring that wealth to the next generation. So I'm happy to be here to present with you all.
And again, my name is Mavis Craig. I'm the director of the Sustainable Forestry and African American Land Retention Project. Similar to Pam, I am a lawyer and had the opportunity to have my own law practice where I worked with from Roanoke, SFLR landowners, which was an honor. But my real estate or my law practice has always centered around real estate. And when my family or when my siblings and I became heirs property owners ourselves, it really made me think about how I use my skills and experience to help others maintain and grow intergenerational wealth. Surprisingly, forestry has been a great opportunity, similar to what it's been for you all. It was a great opportunity for me in doing this work. So very excited to be here. Always great to see the REC crew and, of course, Bob at NC State. So I'm looking forward to this discussion and our discussion tomorrow. Just to cover what we are going to talk about today, we will have a discussion about heirs property. We'll look at what it is, how do we address the challenges related to heirs property, incentives and initiatives for heirs property preservation. And then we'll take a closer look at how you can plan for your family's land and the rest of your estate. Pam is going to guide us through estate planning and what are some really important things to think about and actions that you can take to create or to move towards a good estate plan. So those are our topics for today. We'll get started with heirs property. I do want to encourage you to use the chat box to respond to some of the questions that we asked today. This is interactive. And I'll ask Alton and Pamela to take a look at the chat box while I'm presenting. Let's get started. So first of all, as many of you may know, heirs property refers to land that's owned by multiple people, each of whom have inherited their share. So whether you have a will or not, if the property has been inherited from a family member, then it's considered heirs property. And so that's important for us to all think about. It's also important for us to understand how ownership of property transfers. There's two ways that you can transfer ownership of real estate. Does anyone know? And you can use the chat box feature, but what are the two ways to transfer real estate? In fact, some of you talked about one of the ways in your questions. There's a lot of questions about one of the ways. Deeds and wills. Okay, so if you said deeds, that's correct. And the person who said wills, let's take that a step forward. When does a will become effective? What is the action that requires a will to become? Yes, death. I don't know why I said that so, like, it was so exciting. Yeah, so two ways to transfer in real estate, deed and simply by dying. So we know it happens when people pass away. When people pass away, their ownership of their real estate transfers automatically. In North Carolina, when you pass away owning real estate, the real estate ownership transfers on the date of death. And that's significant because that means the new owners take over. And when we have property transferring by virtue of someone dying, there's no automatic creation of a record of who becomes the owners of their real estate. Instead, families have to go through the estate administration process where you're making an application, you're listing out the heirs, and then completing that process to inform the public of many things, including who inherited the real estate. But many families do not do that process. And with heirs property, what we often see is that there's not a lot of documentation, including estate administration, to demonstrate who became the owners of the property. Contrast that with a deed. A deed is a legal instrument that that informs us of who owned the property and who they transferred ownership to. So it lists the current owner, and then who's named the grantor, and then the grantee is the new owner or owners of the property. There's a legal description of the property. The grantor, meaning the current owner, will sign the document, the deed, in front of a notary, and the ownership or the deed is recorded in the Register of Deeds. And that's significant because that does create a public record of who owns the property. It's something that anyone can go back and reference to see who owns the property. And again, when people are passing away owning property, the ownership is transferring by virtue of the person passing away or the people in the family passing away. There's just no record of it. There are a lot of questions in the registrations about deeds and how they work and how do you add someone to a deed. That's not actually how it works. A deed is used to perform the act of transferring the property. It's not used to maintain an ongoing record of who the new owners are. So we'll talk about that a little bit later, but I did want to point that out that question came up a lot for folks. So property doesn't begin as heirs property. Usually you have an individual or a couple who acquire the land by deed, and they own it while they're alive, and then they pass it on when they pass. They transfer ownership through inheritance when they pass away. So for purposes of today, let's imagine that we have a married couple, and they live in North Carolina. They have 4 children, and when they got married, they purchased 40 acres. So married couple purchases 40 acres of land, built their family home on it, and they have 4 children. All right. So again, let's use our chat box. Who becomes the owner of the property when the first spouse passes away? The other spouse. Yeah, surviving spouse, correct. And that's automatic. So when married couples acquire land, they acquire it as tenants by the entirety. That's an automatic. It's tenants by the entirety. And that type of ownership comes with an automatic right of survivorship. And so, yes, in this scenario, when the first spouse passes away, the surviving spouse becomes the owner. What about when the surviving spouse passes away? Let's say that, like many Americans, neither spouse had a will, and now the surviving spouse has passed away. Who becomes the owner of the property, and what do they get? Again, let's use the chat box. Yes, okay, the children, the heirs. So folks are indicating that the children are the heirs. That's correct. What do they get? What do the 4 children get? Okay, so we have, someone says each child gets a quarter interest, an equal share. All right, 25%. So do they each get 10 acres? Oh, no text yet. Okay, so someone has said they get 10 acres. Someone said no. That's correct. So it's an undivided interest. Yes, we got some smart folks on here. Are y'all lawyers? You don't have to answer that right now. I'm just impressed. I'll say that. So yes, our children, our 4 children, get a 1/4 share. That's an undivided interest in the property. And that's significant because it means that they all are entitled to use of the 40 acres. They're all responsible for the property proportional to their share, both financially and legally. And it doesn't physically divide the property. A lot of people believe that when you have property being inherited by multiple people, that those individuals are entitled to specific acreage, and that's not the case. In fact, they all are entitled to the whole property. So let's look at a family tree over time. Our family has grown. We have the original owners, which are the top 2 boxes in blue. And then the next row is in lilac is the 4 children. 3 of the children got married. That's the yellow boxes. And then all of the children had children. So there's some grandchildren. And then there's even some great-grandchildren, as illustrated by the bottom row. And that's normal. Families grow. Now let's imagine that all of the family members who have an X in their box have passed away. Let's also imagine that they passed away without a will, and that the original owners, the parents, passed first, their children passed the next, the 2 spouses that passed away after their spouses, and then the grandchildren who passed away after their parents. So from the top to the bottom, that's the order of the deaths in the family, and that's everyone who has an X in their box. Based on your understanding of the law in North Carolina, so no will, based on your understanding of the law in North Carolina, how many owners do you think we have today? Again, let's use the chat box. Too many. 8, 9. Anyone else? Any other thoughts? We have too many, 8, 9, 12, everyone. I'm thinking that they meant everyone. We have 16. So you're proving one thing, and that's that we all don't agree on. We don't agree on the same number, which is common among families. People have different interpretations of the law or different understandings of how the law works. And so, yeah, there could be different views on who the current owners are. But in North Carolina, if under this scenario, there are 16 owners. And that's significant because we went from 2 owners to 1 owner to 16 a couple of generations later. And that has to do with our intestate succession laws. So in this family, like many families, there were no wills. And even if they had wills, it's very likely that they would have duplicated the same kind of results because through the wills, people often leave property to multiple people. But looking at our intestate succession laws, this is a set of laws that comes into play when you do not have a will. So if you don't have a plan, the state has a plan for you and your property. So if you die with children but no spouse, it's pretty straightforward. The children inherit everything. If you have spouse but no descendants, so no children, grandchildren, etc., and no parents, then your spouse inherits everything. Then it gets a little bit more complicated. If you are survived by a spouse and one child or the descendant of one child, the spouse gets half and the child or descendants of one child inherit half of your real estate. And then if you have a spouse with two or more children or descendants of those children, the spouse gets 1/3 and the children get a 2/3 share that they split depending on how many children there are. And then it gets even more complicated. So if you don't have children or descendants, but your parents and your spouse are living, then it's half-half or 50-50 between your parents and spouse. And then if you have no spouse, no descendants, but your parents are living, then your parents inherit it. And if you have no spouse, no descendants, and your parents are deceased, then your siblings or the survivors of your siblings inherit your real estate. So it can get pretty complicated, and it really just depends on when someone dies and who survives them. So not a lot of predictability, well, not any predictability at all, actually. So heirs property owners own the property as what's called tenants in common. Oh, someone had a question. There are many owners, but there is still 25% interest based on original owners. Yeah, so to your question, Paulette, the 1/4 shares that each of our, going back to the map, the tree, our siblings, the 4 siblings, they had 1/4 shares. Their 1/4 shares are then divided based on who succeeded them in ownership. So in this case, on the far left, their 1/4 share was then divided into 4s. So their heirs ultimately received a 1/16 share. Compare that to the far right, where we have a 1/4 share being divided by 2, then they have a 1/8 share. So the fractions can get pretty funky depending on each person's heir. So heirs property is owned as tenants in common. Remember, I said earlier that when married couples acquire land, they own the property as tenants by the entirety. With heirs property, they own it as tenants in common. And that's the same kind of treatment, the same legal rights as if all of us on this call, all 71 of us, were to acquire property together. We would also own it as tenants in common, even though we're not married. So they treat heirs property, they treat family land the same way they treat land owned by individuals who are unrelated, which kind of makes it difficult for families to keep land in the family and to manage it together, which I'm sure many of you are familiar with the challenges. Any of the owners has the right to transfer their share to a third party. They don't need permission of the other owners to transfer their own share. Any owner can, any legal decisions that are made about property, even something as simple as whether to provide a hunting license on the property, but it could be even something as complex as whether to sell the property or to borrow against the property. It requires unanimous decision-making among the owners. And again, if we have numerous owners, whether it's 3 owners or 16 owners or 71 owners, it requires unanimous decision-making. Any owner also has the right to seek physical division of the property, which is called partition. And if someone is interested in physically dividing the property, again, they could do that if there's a unanimous agreement among all the owners. However, if there's not agreement among the owners, any of the co-owners can go to court to seek a physical division of the property. If the court cannot divide the property equitably, meaning that if they can't divide it proportional to each owner's share and the characteristics of the land are not consistent across the property, then the court has to force the sale of the property. That's called a partition sale. And that's where we get into land loss. A lot of times, partition sale actions are brought by third parties who purchase a share of a family member's heirs property and then uses their legal right to seek a forced sale of the property. And that's what's contributed. That's what's contributed to a lot of families losing property in North Carolina and South Carolina, Georgia. A lot of times when we hear about Black land loss related to heirs property the loss along the coast of South Carolina and Georgia is often referenced because many of the families that were enslaved acquired a lot of land along the coast in the Sea Islands of South Carolina and Georgia. And then when those areas became desirable for vacation resorts and so forth, real estate developers, unscrupulous folks came in and bought shares, sometimes under duress, from individual owners and forced to sell the property and were able to acquire it at auction. So the legal structure of heirs property is very challenging in that it can be a source of conflict, it can make it difficult to manage the property, and it can even result in loss. There are also social challenges with heirs property. Folks are becoming co-owners of property together, and they may not have chosen to co-own property together with other folks. They may not have good relationships or communication. They may not even know the family members. And so it can create challenges. Oftentimes you'll have co-owners who are taking responsibility to keep the property up and make sure it's taken care of, and take care of things like property taxes or pay the mortgage so that the property stays in the family, and other family members aren't doing anything at all. And it builds resentment and can create a lot of rife amongst family members. And then the financial aspect of it could be challenging for folks. You're becoming an owner involuntarily, and by law, you are legally responsible for the property and financially responsible for the property. So things can get really complex.
Here's a question in the chat.
Yes.
It's, can a sibling without children leave their portion to their niece and nephew?
Yeah, so any owner can transfer their share to whomever they want while they're alive. And if they have an estate plan that includes a will or trust, for example, they can provide the property, their share of the property goes to whomever they want, whether it's niece, nephew, Mavis, Pamela, Alton. So yes, you can transfer your share to whomever you want. Someone mentioned the Torrens Act of 1868. So the Torrens Act is a very archaic law that we have in North Carolina, and it exists in other states as well. But it has to do with clearing title and asserting rights on property. I won't go into it deeply, but I will say that it has been used as an abusive practice as it relates to family-owned land, even among family members. Some of you may have seen or read an article that came out a couple of years ago, or maybe last year, about a family where one family member was able to get ownership of the property in their name solely using the Torrens Act. I'm hoping North Carolina will do away with it, because it really only has been used for negative things in the present times.
We have another question.
Oh yeah. Okay.
If there is a lien or judgment against a property owner, can he or she be forced to sell his or her interest?
Oh, that's a great question. So that's another aspect of the financial challenges with heirs property and the legal structure, is that creditors of any owner can attach a lien against that owner's share. They can't force the sale of the property, but if the property is ever sold, or if there's any income on the property, legally that creditor has to be paid. And again, it's proportional to, it's directly connected to that owner's share. Really depending on the value of the property and the amount of debt, the likelihood that a creditor would attach to heirs property. And again, because many people, there's not really a strong record of, a lot of heirs property doesn't have a clear public record of how the ownership is transferred. So it's legally possible, but it really depends on the circumstances and whether a creditor was able to find out. So an example I could think of is if there was an estate for a deceased person and their share of the heirs property was listed on that estate, and then through the estate process, the creditor became aware of that. There's still some hurdles that have to be met before the creditor can get a judgment against real property, but technically it is possible. Great question. All right, So how do we make family land ownership work? Ideally, we're going to put ownership into a single entity and create the management structure that is suitable for our family, our land, and for future generations. And so one type of entity that you could use is a trust, and Pamela is going to talk to us more in depth about trust later. Another entity that you can use is a limited liability company, or a family partnership. There's various business entities that you can use, but most commonly we think about limited liability companies as a good model for succession planning for family-owned land. In a limited liability company, you have the company is created by filing the appropriate paperwork with the state of North Carolina, and the current family member owners will transfer their shares into the limited liability company. So the company owns the real estate, and then the family members own the company, and the family members will sign what's called an operating agreement. And I should note that you're not required to have an operating agreement in order to create an LLC, but there's no sense in creating an LLC if you don't have an operating agreement, because that's the heart of what makes an LLC useful for managing intergenerational family land. That operating agreement is the document that's going to govern how the property is managed, who's in charge of the day-to-day, and what kind of decisions they can make, what kind of decisions can the owners make, what happens with the share of any owner who passes away, or if they no longer want to be an owner. So the operating agreement is key to a limited liability company. And again, Pam is going to speak later about how trust works, and we can make the connections for trust with heirs property at that time. However, the entity, while the entity is the goal, it's not the first step. The first step is confirming who the legal owners are. And for many families, we have to start with the family tree. The family tree descending from the original owners or the owners on the last deed of record all the way to the youngest generation in the family. So it's not your typical family tree. Instead, it's a family tree that is aligned with the original owners of the property, or the last deed of record that reflects the owners of the property, and then tracing the family tree from them to the youngest generation, being very inclusive. And I know families are dynamic, and there's people we consider family and people we don't consider family, but you want to include everyone. You want to include quote unquote adopted people, people who are legally adopted or socially adopted. You want to include people who are born of a marriage, people who are not born of a marriage. You want to include spouses. You want to include everyone, as many people as possible, everyone in the family. Don't make the decision of who you don't like or you don't think is family. Leave that up for the attorneys. But you want to include for each person who has passed away, their date of death, where they passed away, whether an estate was administered, and who survived them. And I know that's a lot of information, but it's really important information, and you should try to get as much information along those lines as possible for everyone who's passed away. So again, in the family tree, we want to trace from the last deed of record to the youngest generation of family members. We want to be very inclusive. And for anyone who's deceased, we want to know when they died, where they died, whether an estate was administered for them, and who survived them. And I recognize that it may not be possible to get all of that information. There may be some gaps, but to your best ability, you want to have as comprehensive a family tree as possible. And then once you have that family tree, then you want to go to an attorney. So you don't want to come to an attorney first, because you don't want to pay an attorney to do the family tree. But the attorney can actually rely heavily on the family tree to build the chronology of the family's land ownership. And so when you go to the attorney with your family tree, your ask is that they complete what's called a title search and form a legal opinion of who the current owners are. If you've ever purchased your own house or property, part of that process of purchasing was having an attorney do a title search. In this case, the period or the scope of the title search really is informed by the family tree and when the property came into the family. So it's important to work with an attorney who is very familiar with real estate and estate law, and to work with someone who's willing to have some flexibility with how you work with them. I don't think you should go to an attorney and say, hey, I want you to put this property, we want to put this heirs property into a trust or LLC. And then the attorney say, hey, okay, give me $5,000 and then we'll just bill against that. And then they come back and say, give me $5,000 more. No, I think first you should limit the scope to the title search, and you may even want to limit the scope of the title search to a set number of hours. When I have my practice, I would suggest that you give me enough money to cover our first meetings and 5 hours to perform the title search. When I have spent 5 hours on your matter, that's a check-in point. That's a benchmark for us to see where we are and whether it looks possible to continue on that journey towards the single entity. You may find that the goal that you're seeking is not possible, and that you have to instead develop a different strategy, such as using legal action to confirm who the owners are. And I'll talk about that in a minute. But once you have a confirmed opinion from an attorney of who the current owners are, then those owners need to have a discussion and make decisions about the property. And it may be that you have people who want to continue to be owners or continue to be connected with the property, and people who don't want to continue to be connected with the property. And so I think it's important to be really strategic in having those conversations. Maybe you need to bring in a third party as a mediator or a facilitator to hold the discussion, because, you know, depending on the family dynamic, it could be a very difficult discussion to have and to facilitate. And there are professionals who can offer group facilitation services to take that burden of the facilitating the process off your shoulders so that you can just participate fully as an owner. But in that decision making and discussion, it's important to identify who's going to remain involved, who's not going to remain involved. What are the long-term goals for the land and how it's used, et cetera, and then have the attorney counsel you on the ownership structure that's most suitable for those goals and the decisions that the family is going to make. Of course, there are alternatives to putting ownership into a single entity owner. You could always maintain the current situation, which a lot of people do because it does feel overwhelming. You could enter into what's called a tenants in common agreement. So that's a contract between the owners around how the property is used and who can use it, et cetera. And you could even agree to a different voting structure instead of unanimous voting. But the tenants in common agreement is not necessarily going to survive past the current owners, and you'll have to, when owners pass away, you'll have to ensure that the new owners, new co-owners, are in agreement with the tenants in common agreement. So it's not ideal, but it is something that could at least be a placeholder while you address some of the other issues, such as what type of entity to use, and so forth. And then, of course, you could physically divide the land. One thing that I don't like among my peers, my fellow attorneys who work with heirs property owners, is that they often go to this solution that they, you know, if there's multiple owners, it's confusing, people may not like each other, let's just divide the property up. And I'm sure Alton and his crew can tell you and have told you before, if you divide the land, the value, the economic value is also divided and decreased. You know, harvesting timber off of 25 acres versus harvesting timber off of 8 acres is a big difference, even if they're considered smaller parcels. So it's not ideal to physically divide the land, and it's certainly not ideal to go to court. When you go to court, if you have a co-owner who says, you know what, I don't get along with them, I want to go to court and I want the court to divide the land, or I want the court to sell the land, you're putting the decisions into the hands of someone who knows nothing about your land and probably doesn't care about you or your land. They're just tasked with making decisions around whether the property can be divided equitably, whether the property should be sold at auction because it can't be divided equitably. And I just want you all to think about, you know, where what county your land is located in, and do you know the clerk of court? The clerk of court is the person in North Carolina who makes the decisions about partition actions. And so usually the clerk of court isn't really looking, I mean, I'm not saying clerks of court are bad people, but they have a task. Their task is to find a resolution based on the law. And they're not going to necessarily take into consideration how hard your grandparents worked to get the land and how the land fed you and helped you go to college. And so that's why I think it's best to avoid that, that action. And there are a lot of incentives to address the legal challenges. I'm assuming that many of you here are familiar with one of the first incentives, which is, forestry and traditional agriculture and conservation opportunities. Land is, when you have acreage, you have multiple acres, there's benefits to not only your family, but your community and your state, related to conservation, related to carbon sequestration. And so it's important to think about the natural characteristics of your land and how that can benefit not only you and your family, but those around us. There's also intergenerational wealth and stability to consider with family land. For many families, a lot of their wealth is situated in land. Even if the land itself isn't of high value, the fact that it's part or a significant part of the family's intergenerational wealth is significant, and it's something that should be cared for. You also, when you address the legal challenges, particularly clearing title, clearing the ownership, and confirming who the current legal owners are, will be able to gain access to resources, including disaster recovery. In North Carolina, the disaster recovery / mitigation plan, in its first iteration, did not actually have mechanisms to support heirs property in disaster recovery because you can't prove that you own it. They have made some adjustments, but it only goes back one generation. So if you have heirs property that you inherited from the last owner that's on a deed of record, then you could access the disaster recovery. But if it goes back further than that, at least my interpretation of the plan is that it does not, you cannot qualify for it. And that includes other disaster recovery such as FEMA. You cannot get FEMA benefits if you do not have clear title, and that is something that harms many heirs property owners. And then, of course, you can't confirm legal standing to address environmental justice and other issues. If you can't prove that you own the land, then if your neighbor is spraying hog waste on your land, you can't sue them. Well, there's other reasons why you can't sue them because our statutes are bad, but if you can't prove you own the land, you don't have legal standing to sue them. And that could even be a boundary dispute. So it's really, there's a lot of reasons why you should address the legal challenges, even if they feel insurmountable. I just want to show you this map, these two maps of North Carolina to go along with this discussion about environmental justice and so forth. This map illustrates heirs property across the state of North Carolina. The red, that's indicating heirs property across the state of North Carolina. So if we take a look in the northeastern part of the state, there is a significant amount of heirs property. And then it's overlaid with data around the proportion of Black residents in each of our counties. And again, if we look in the area where Roanoke Electric is, it's very Black and lots of heirs property, except I don't know what the one county is in the middle that kind of doesn't have a lot of heirs property. It may be that we don't have enough data from that county, but that's significant. So there's a lot of heirs property where many of our Black families live. And then let's look at this map. It's blurry, I apologize, but this map basically illustrates all of the coal ash sites in North Carolina, all of the confined animal feeding operations, the Atlantic Coast Pipeline, which is no longer being pursued, and then coastal flooding. So again, thinking about where heirs property owners or where heirs property is in North Carolina, or where there's lots of heirs property and where there's lots of potential or actual environmental injustice, that's pretty significant. That's a lot of land that cannot be defended if there's some sort of environmental justice. So, again, just looking at both maps, there's significant intersections with ownership of land and where some of these impactful environmental activities occur. So there are initiatives and policy that support AIR's property preservation, including the Sustainable Forestry and African American Land Retention Project, of which Roanoke Electric was one of the first sites. We call them we call the organizations that do the on the ground work with the landowners SFLR sites, and Roanoke Electric was one of the first ones, and has been tremendous. And what's wonderful about Roanoke Electric is that they've extended this program to all of their members. There's also the Land Loss Prevention Project, which is a nonprofit law firm representing Black landowners. They've done a lot of work with Black farmers who were discriminated against by USDA back in the day. There's the Uniform Partition of Heirs Property Act. So remember the partition actions that I mentioned before, where an owner can go to court and say, hey, we want the property divided, or we want it forced at auction. The Uniform Partition of Heirs Property Act provides some additional due process rights when it comes to family-owned lands, meaning that if heirs property is subject to a partition action, there's certain considerations. For example, the petitioning owner has to offer their share to the other owners at fair market value. And if they don't purchase the share of the petitioning owner or owners, and the property is sold, the property has to be sold at fair market value. That legislation has been adopted in 17 jurisdictions. So 16 states and the U.S. Virgin Islands have adopted this legislation. North Carolina has not yet adopted that. Alston and I have been part of a coalition of North Carolina organizations that are seeking to get this legislation passed this year. And the wonderful thing about this legislation is, in addition to the due process rights that it gives heirs property owners, there's also a connection to access to resources in the U.S. Farm or through USDA, which was mandated under the 2018 Farm Bill. So the 2018 Farm Bill had provisions for getting a farm and tract number. So historically, heirs property owners have not been able to get a farm and tract number if they cannot confirm or prove that they own the property. So that cut off access for a lot of people. Well, with the 2018 Farm Bill, it says if you are in a state where where the Uniform Partition of Heirs Property Act has been passed, then here are the documents that are required to get the farm and tract number. If you're in a state that has not adopted it, then the regulations lay out how that happens. And I'm not quite sure what those regulations say. They just only recently came out 2 years later. So those two things are really positive for heirs property owners. And I think we're seeing even more legislation in Virginia. They just, they're about to get new legislation where if there's delinquent property taxes, there's certain, and it involves heirs property, there's additional requirements of the municipality before the property can be foreclosed on. So that's good. And hopefully we'll get legislation like that in North Carolina one day. And then North Carolina Legal Aid. Oh, sorry.
No worries. We have some questions. One is particularly related to the bill you were just discussing. They asked, has a numbered bill been introduced for the Uniform Partition of Heirs Property Act?
Has the bill been introduced? Not yet. I think, Alton, correct me if I'm wrong, I think the plan is to begin that process next month.
Yes, that's correct, Mavis. It has not been introduced yet. The coalition is currently working on strategies to introduce it in the long session.
Yeah. Another question is, if the land is partitioned, does the family members have a say in which portions they receive? Mm-hmm. So that depends. If the partition action is voluntary, not partition action, if the physical division of the land is voluntary, meaning that all of the owners agree to physically divide it, then yes, then they can decide how they divide it up. But if it goes through the court, that power is stripped away. Instead, the court is going to appoint commissioners. They're called commissioners. They're going to appoint 3 people who are tasked with determining how it's divided up. And those 3 people are going to work with appraisers and surveyors and so forth and make a determination of whether it can be divided equitably, proportional to everyone's share. And if it can, then they will decide how it's done.
Okay. We also have 2 questions about LLCs that were posted. Can you legally keep spouses from having an ownership share if an owner is married? That's one. You might want to address that one first. And then do
Okay,
owners...
can you?
Go ahead.
Sorry, go ahead. No, go ahead.
I was just going to go over the second question. You see it?
Oh, okay. I see. Yeah, I do. So one question is, can you legally keep spouses from having ownership share if an owner is married? I will say that yes, you can keep owners, but it would require a comprehensive plan. It would require having a plan that ensures that non-blood family members do not become owners. So that would not be achieved by using deeds or by using wills solely for your planning. It really does require having something that can last for multiple generations and addresses non-blood members. And then another question is, do owners have the right to sell their share? Yes, they do. It's about LLC. So in the operating agreement, that's why the operating agreement is so important with the LLC. In the operating agreement, you should cover that particular question. And my recommendation is if you want to limit that, then the operating agreement should say that owners of the LLC can only sell their share to other owners, or the other owners have to agree by X percentage that the share could be sold to a third party, which I don't think it makes sense to allow the shares to be sold to a third party, but it is important to address that in the operating agreement. I'll look at one more question before we move on so that we can have time for the for Pam.
I think that's all the questions. Oh,
okay,
yeah.
Wonderful.
If land is partitioned, do family members have any option? I think you covered that on which.
Yeah. And okay, great. Yeah. Okay. Well, I'm going to hand it off to Pamela, and we'll have more time towards the end during the question and answer session to answer more questions. But I think now is a great time to start with estate planning, because at the end of the day, it's important to plan now. And there are a lot of ways that you can go about planning, and sometimes there's multiple things that you want to implement. So Pamela, let me turn it over to you.
Okay, great. Thank you. So we're going to talk about all the documents that are involved with an estate plan, and why it's important that you have one, whether you have heir property or not. This is a very important step to take to pass wealth on to the next generation, and to make sure it goes to the people that you want to receive it. And so typically people don't think about doing their estate plan until they've had to deal with the death of a family member who didn't have an estate plan in place, and then they have all kinds of challenges in making sure their assets go to the appropriate heirs. And it can cause a lot of family division and strife. And so it's really, really important to do, but it's not something that has to be done. So a lot of times people don't make it a priority. Life gets in the way, you're really busy, and you don't realize how important it is. So we're going to talk about the different documents, which are a will and trust. Those are the main documents, but they're powers of attorney that are also helpful. Financial powers of attorney, healthcare powers of attorney, and a living will. So we'll just get started with that. And so going back to this slide you've seen before, this is the slide about what happens to your property if you die without a will. And so typically I typically ask people if they have one, and if you don't, the government has one for you. So this is the will that the government has for you. if you don't decide who gets what. And it's really, really important to make sure you understand this, because a lot of times people don't understand who they can end up owning property with. So for instance, in the more complicated situations where you have a spouse, but you don't have children, and you end up, but you have living parents, and you pass away, your surviving spouse could end up owning property with their in-laws. And maybe people have a good relationship with their in-laws, maybe they don't, but most people don't want to own property with your in-laws. In particular, this can happen with your primary residence. So it's very, very important to think about what scenarios could occur if you don't have a will in place, because as Mavis was mentioning, when you are a married couple and you own property together, when it's purchased together, you automatically own it as tenants by the entirety. But if you, for instance, marry someone who already had a house and you just move in with them and they haven't added you to the deed, you don't have this ownership with the primary residence. And if that person doesn't have a will, then you run into the situation where, like I said, with a surviving spouse and no children, but you have parents, then you could end up owning land or that primary residence with your in-laws, your spouse's parents. Likewise, if you are in a blended family where there's a second marriage and you and your spouse had property before you married, such as your primary residence or a vacation home or a rental property, and there is no will in place, then the surviving spouse will end up owning property potentially with their stepchildren. And when there are 2 or more children, the children inherit 2/3 of the property. So you have the potential situation where a surviving spouse could end up owning a primary residence and have a 1/3 share, and the stepchildren have a 2/3 share. So you really want to think about these situations, because people don't often look and see, okay, how do we own this property? Is it truly tenants by the entirety? And did we purchase this property together? If we didn't, is my name on the deed so that I will have a right of survivorship interest? And then you want to make sure that if there's a second marriage, you definitely want to think about that situation. So owning property and not having a will can create a lot of difficult situations. So you want to keep that in mind and make sure you know how you own property while you're alive, and then figure out how you want it to pass after you die. So next slide, Mavis. Okay, so let's just talk about what kinds of assets you have. Real property, tangible property, intangible property. Those are the different kinds of assets that you want to think about. So we've been talking a lot about real property, your primary residence, rental properties, any vacation homes, just vacant lots that you may have inherited. So those are the kinds of real property assets that you may have. Tangible property includes your vehicles, art collections, coin collections, furniture, anything you can put your hands on, that's considered tangible property. And then intangible property is property such as your ownership in a business, insurance policies, intellectual property, and bank accounts, brokerage accounts, and retirement accounts such as 401ks and traditional IRAs. So these are all the things you want to think about. How do I own? What do I own? How do I own these? And who do I want to transfer these assets to? And that's all part of what you consider in your estate plan. Okay, next slide. Okay, so the documents that I mentioned are the powers of attorney, healthcare directives, wills, and trusts. So let's talk about the powers of attorney first. And so you have the durable power of attorney, which is your financial power of attorney. And this document names an agent that can serve on your behalf to make financial decisions for you if you are incapacitated and not able to make them for yourself. So your agent makes these decisions while you're still alive. This power ends at death. So you do not have the power to make any decisions using a financial power of attorney document after someone passes away. So this document has a lot of broad power. I ask people to think about who they might want to name as their agent. Typically, spouses name each other. But then once a spouse passes away, then you have to think about who would be the next person to act as your agent. And so when you're considering whether you would want your children or a friend or another family member to serve as an agent, I always ask people to think about someone who manages money well and has money of their own and doesn't need yours, because there are situations where they can get access to your funds and have a lot of control to use your funds for their advantage instead of for your advantage. So you want to make sure that you have the right person in mind or the right child in mind. And one of the other things I suggest is that you pick one person instead of having co-agents. A lot of times family members or parents in particular want to be fair to all the children. And so they want to give every child an opportunity to serve. And that can create friction, especially when they have different views on how money should be managed. So it's important to know which child or relative or friend can properly manage the money before you give them this kind of authority. The healthcare power of attorney is different because that one allows you to direct someone to be your agent, but that person will make healthcare decisions for you. So whether you need surgery, if you've been in an accident or in a coma and you can't make decisions for yourself, and whether you need a certain type of medication or some type of medical procedure, or need to be put into an assisted living facility or a nursing home, this agent will help make those decisions for you. And so you want to pick someone who will be able to be emotionally stable to make decisions about your health care, so that they won't fall apart, knowing, oh, mom's in the hospital, and, just fall out and can't handle it emotionally. So you want to pick someone who can make good decisions and communicate with the healthcare professionals and understand what's being said so that they can make the best decisions for you. Now, one thing I also try to advise people when you're picking the agents, like I said, typically spouses choose each other first, but you run into issues when one of the spouses has passed away or there is no spouse. And so then you're picking someone like a child or a relative or another relative or a friend. And so you want to make sure that when you pick that person, you consider also who you chose to be your financial power of attorney. because these two people will have to work together. So a lot of times people don't think about it. So your financial power agent should be able to manage money well, and your healthcare power agent should have the emotional stability to make the decisions on your behalf for your healthcare. But they need to work together, because if there is, let's say, a medical procedure that you might need, and there is a cost to that medical procedure or cost to that living facility, we want to put mom in the best living facility, and then the person with the purse strings, the financial power, says, no, I'm not paying for that. So you have to make sure you consider how they will have to work together. So that's very important. And sometimes that's not something that people think about when they're choosing their agents. Now we'll go on to healthcare directives, and that's basically the living will. They have other directives, which I won't go into for mental health. They do have a do not resuscitate order, but we'll talk mainly about the living will, which is a separate document, separate from your healthcare power of attorney. And it basically expresses your desires for a natural death if you are in certain terminal conditions. So the statute kind of lays out those conditions if you are in maybe end-stage Alzheimer's, in a coma without hope of recovery, or in the end stages of a terminal disease. And typically what happens is people can make a choice to say, please provide life-sustaining measures for me in the form of artificial hydration or artificial nutrition, or please do not provide those measures. And again, you want to think about whether you want to make that decision or you want to let your healthcare agent make that decision, because you can actually leave that decision to your healthcare agent, and those provisions can be a part of your healthcare power of attorney. But if you think that someone might not let you go and you want to go on if you're in certain end of life conditions, then you want to have a separate living will that tells the doctors, okay, please don't provide these life-sustaining measures for me and just let me go. And you have options on which types of measures you want to have, whether it's artificial nutrition or artificial hydration. And I always suggest that people talk with their doctors to just get an understanding of what it means to have both of those, or one and not the other. And so that is a decision that you can take out of the hands of your healthcare agent and make it yourself. And a lot of times people do say, okay, let me go. But a lot of times people will say, well, no, keep me alive, because they might just say, oh, she's lived a good life, let her go. And so I want you to do everything to keep me here. So it's really just up to your preference. But that is a document that you need if you want to take those decisions out of the hands of your healthcare agent and make them yourself. So that's a personal preference. So now we'll go over wills and trusts. And so as far as a will is concerned, it is a document that most people are familiar with, and it's a way of transferring your property to the next generation, to your heirs, and telling the court who you want to receive which assets that you own at the time of your death. Now, a will is a public document, and so that's important for people to know. And I think most people are familiar that when you have a will and you pass away, then it names an executor, or executrix if it's a female. And that person, and also North Carolina uses the language personal representative. So, and that's gender neutral. So you have a personal representative, also known as a PR, and that person takes your will to the courthouse, and then the clerk of court supervises the process of transferring your assets. So that executor or that personal representative has to kind of gather all the assets that you have and report those assets to the court and pay fees for transferring those assets, fees for receiving those assets into your estate, and then making sure to distribute those assets to the heirs. And so when you have a will, the will determines who gets those assets. So it's very important to have one. In particular, when you have minor children, it's important to have a will because you can name a guardian for your children in that will, and make sure they don't end up in temporary foster care while you're determining who would have custody of the children. And this is typically the case when both parents pass away. Typically, if you have children and you have two parents in the household, then the surviving parent obviously gets custody of the children with no question. But if the parents die in a common accident and the children are minors, then you have that issue of who would be the guardian. So that's something to think about. And so as far as the will is concerned, you want to make sure you know that that is a public document. It passes your assets on to the next generation, but everything can be viewed by anyone. So anyone can go down to the clerk's office and look at the assets that you have in your estate and who you gave them to. And there are also fees associated with having your assets go through what's called the probate process. And in North Carolina, what those fees are mandated by statute. So for every $100 that you pass, you pay 40 cents on those assets for every asset that's transferred. And North Carolina has a cap. So you would never pay more than $6,000 in court fees. And that would equate to about a $1.5 million estate. But so if you pass more than $1.5 million, then you won't pay any more than $6,000 to the court. But those are not the only fees that you would pay. So that's just the fees to transfer your assets. And those are court fees, but those are not attorney's fees or other fees, such as getting an appraisal done for certain assets so that you can report the correct value to the court. So, and just to make you aware, the clerk's offices can provide the forms. You're not required to hire an attorney to administer an estate. The heirs can administer the estate without the assistance of an attorney. In some states, you are required to hire an attorney to help you administer an estate, but you're not required in North Carolina. However, if any of you have had to administer an estate and you've gone to the clerk's office, they will tell you, we cannot help you fill out these forms. We can provide them to you, and we have a booklet available for you to figure out what the process is. But if you have questions, you will need to hire an attorney. So there are fees associated with that. Now,
Pamela, I just wanted to, if I may add that if someone at the clerk's office tries to help you, you should be cautious, because I've had situations where clerks, being generous, have given advice that is very devastating. So
I agree. Yes, that's very true.
An
And
attorney.
they are, some of them are attorneys, but most are not. And the statute actually tells them that they cannot commit the unauthorized practice of law. So they really should not be helping you. And a lot of times, like Mavis said, they will give you incorrect advice that can be very detrimental. So be mindful of that. So now you've got the will that takes you into the court process. And Mavis, again, if you would help me, please, if there are questions, if I missed them in the chat, because I think I see someone saying there's an executor's bond and another fee, and some people may not be able to get a bond. That is very true. So in addition to the transfer fees that you pay to the court and the attorney's fees and the potential appraiser's fees, then you have to post a bond. Now, in your will, you can say, I waive the bond requirement, okay? So then you don't have to pay an insurance company. Basically, the bond is, you have to get an insurance company to insure in case the executor runs off with all the money. And so the heirs can still be covered. And there's a fee for that that can range anywhere from a couple of $100 to a couple of $1,000. And they base that on the assets, the value of the assets in the estate. So if you have a will, you can waive the requirement for a bond. But if there is no will and you still need to transfer assets, you still go to the court and you are required to have a bond unless all the people who are eligible to serve as administrator waive the bond requirement. And so let me go back for a minute and explain what it means when I say all the people who are eligible to be an administrator. So when you pass away without a will, there's an hierarchy again of who can serve as the administrator of your estate. And if you are married, then it's simple. It's the surviving spouse. They have the first right to serve as your administrator. So, and let me just make sure I'm clear. When you pass away with a will, you have an executor or an executrix. When you pass away without a will, you have an administrator, okay? So when you have an administrator, like I said, the surviving spouse would be the first person who's eligible to serve, and they don't need to get anyone else's permission. However, if there is no surviving spouse, then you have an hierarchy below that, which would be children, if there are any. And so if you have one child, then that child serves as the administrator, there's no issue. But if you have two or more children, then you have to decide, the children have to decide which person is going to be the administrator, and the other siblings have to renounce their right to be an administrator. And so they have to sign a document that says, I would like for my sister or brother to be the administrator, and I don't want to do it. So they also can sign a form to waive the bond. And I have had situations where siblings renounce their right to serve as administrator, but they would not waive the bond because they didn't trust the sibling. So, you know, that's something to think about. But going through the court process is involved. It's a process that can take anywhere from a few months to a year or more. And I've had some estates that have remained open for several years. So just depends on the complication of the process. So that's wills. And like I said, it's a public process. But now we're going to go and talk about trusts. Excuse me. And so trusts are, they are, thank you, Mavis. That is a different kind of way of transferring assets to the next generation. And there are lots of benefits to having a trust. So let's just talk about what a trust is first. It's a contract, it's a legal agreement between the person who creates the trust, which would be the trust maker, the settlor, the grantor, and the person and the trustee. And so that person is going to create a trust. Then you're going to have a trustee who is the legal owner of the assets that the creator puts in that trust. And then that trust will have beneficiaries. And those beneficiaries just get the chance to enjoy the assets. They don't have any legal ownership, no responsibility to manage the assets in the trust. They just receive all the benefits. They get to spend the money or enjoy the property. So when you have a trust, that contract in itself creates dual ownership. So the trustee has the legal ownership and the beneficiaries have the beneficial enjoyment of those assets. So that allows for a lot of protection. So when you have a trust, there are different reasons why you want to think about having a trust. First of all, it creates a level of privacy. So unlike a will, where you have to take it to the clerk of court and go through that probate process that I just explained, you don't have to do that with a trust. With a trust, it's a private document and no one needs to see it other than the trustee and the beneficiaries. So someone can't go down to the courthouse and say, oh, I know they had a lot of money. Let me see who they left it to and how much it really was and who got it. So no one will know the terms of the trust, okay? And with a trust, you can set it up to last for certain generations. So what happens with a will is when you leave property to someone in a will, that is the end. You don't get to control what happens to it after you've given it to that person. So for instance, when my grandmother passed, she had remarried. And so her husband was not the father of her children. So she had land that she wanted him to benefit from, but she didn't want him to be able to control where it went after her death. But she did not know this when she went to draft her. She only had a will. She didn't have a trust. So unfortunately, she went to an attorney that did not know what they were doing, sadly. And I wasn't even a law student at that point, much less a lawyer. And they drafted it such that she gave the land to my grandfather and then to my step-grandfather. And then after he died, it was supposed to go to her children. Well, you can't do that, not with a will. And so I'll go back to that story because I have more to tell about that. But it turns out that her will was not valid. So it worked itself out, sort of. But just the fact that people think that you can transfer an asset to a person via will and then control what happens to it after that person that you transferred it to passes away, that is not something that you can do with a will, but it is something that you can do with a trust. Now, before I go into how you do that, I wanted to also say that you can grant someone a life estate in your will, which says they can use this property for life, but then after their death, it goes. But that's the only other way you can do it. But you can't give it to them outright and then expect that after they die, you can control where it goes. That person then has the control. So with
Hey, Pamela,
Mhm.
two things. One, just a time check. It's about 7:21.
Oh, okay.
And then there's a question. How does the trust work if you end up having to go to a nursing home and Medicare is looking at your assets?
Okay, so I will speed this up a bit, but that is a slightly different question. So there are several types of trusts, let me say. There are revocable trusts and irrevocable trusts. And so I'll just keep it within that category, within those two categories. So when you're dealing with Medicaid, you're talking about an irrevocable trust, okay? And so that is for asset protection. What happens is when people have built up their savings and they want to be able to pass it on to the next generation, but they might need to go into a nursing home. And many of us have experienced people who have had to, in our families, who have had to go to nursing homes, and they are not cheap. It's very expensive to go into nursing facilities, and they can cost anywhere from $70,000 to $100,000 a year. You can pay anywhere from $7,000 to $10,000 a month for a nursing facility. And so that will eat up all of your savings. So there is a mechanism where you can create an irrevocable trust that will put your assets in that trust so that you can qualify for Medicaid. Now, just briefly, I won't go into a lot of detail about Medicaid, but in order to qualify, there is an income limit and an asset limit. And with Medicaid, you cannot have more than $2,000 in assets. And then your income, it ranges based on the number of members in your household, but the range is from about $16,000 a year up to about $34,000 a year in income. That's about all you can have based on whether you have 1, 2, 3, or 4 more members in your family. So you cannot have much income and you cannot have basically any assets. Now, I say that with a caveat because they do allow you to have things like 1 vehicle and a primary residence and a few other things. But you can't have a whole lot of liquid assets. And so what happens is, unfortunately, people need nursing home care. They can't qualify for Medicaid, and they end up spending all their assets because they force you to spend down to nothing before you can qualify, spend down to those limits. And some people can spend their assets down to those limits, but then if you're receiving Social Security income or a nice pension, then you can't qualify because of the income limits. So you put your assets in a trust, an irrevocable trust, and then that takes the assets out of your estate so that you could qualify for Medicaid. But there is a huge caveat, and it's very important to plan ahead of time because there is a 5-year look back rule. So if you make this transfer into a trust the day before you need Medicaid, or even the year before you need Medicaid, you will not be able to qualify. What will happen is the state will make you private pay until your assets are depleted to a point where you can qualify. So they consider that a transfer that's not sanctioned, not allowed, and they will not allow you to qualify until they have a formula that they calculate to say how much you transferred and how long you have to private pay until you can qualify. So you really want to make this kind of transfer into a trust 5 years, more than 5 years before you need it. And that is often something that people don't anticipate. They don't know that rule, and so they don't know to do that. There is crisis Medicaid planning that can be done, but again, whenever something has crisis attached to it, you know, it's stressful and it's not necessarily going to be the ideal situation. But there are other options if you're not able to plan ahead 5 years before you need Medicaid. So that's one of the uses of an irrevocable trust. And so now I'll backpedal a little bit and tell you what the differences are between revocable and irrevocable trusts. So revocable trusts allow you to make changes during your lifetime. With an irrevocable trust, you cannot change it, or that's the law, but there's always a way around the law. So they can be changed, but not with ease. And a lot of times you need a court order to change an irrevocable trust. But they serve different purposes. So a revocable trust is more for privacy and protecting the next generation, where an irrevocable trust is more for planning, protecting your assets, and also removing assets from your estate for different reasons, mainly either qualifying for Medicaid or for saving taxes. So a revocable trust won't help you save taxes, but an irrevocable trust will. And if there are any specific questions about that, we can go into more detail. But in the interest of time, I'm going to go back to revocable trusts because those are the most common. And those are the ones that most people have as a part of their estate plan. And so, like I said, this is a private document, and it allows you to leave assets to more than one generation. And it also allows you to protect the people that you're leaving the assets to. So creditor protection is very, very important. So when you are a beneficiary of a trust and you have no legal ownership, that means creditors cannot force you to take assets out of the trust to pay them. So for instance, if you have a judgment against you, if you're a doctor and you've got a malpractice lawsuit against you, then you can't be forced to take the assets out of the trust because you don't legally own them. You're just a beneficiary. The trustee owns them. And so, or a creditor could be a divorcing spouse. And so if you are going through a divorce and you're working with an attorney and you're trying to equally divide the assets, then the assets that were left to you in trust are not considered. So in the equitable distribution. And then one really important aspect for a trust is protecting the bloodline. And so I always use I commonly use the story of Cinderella because everybody knows that story. Cinderella had two parents, her mother died, and her father loved her dearly. He married this evil woman, and then he died. Okay, and then this woman took his money, took care of herself and her children, and put Cinderella in the basement. Well, that's because Cinderella didn't have a trust. And so that can happen when you have blended families. Everything is fine while everyone's alive. And I'm sure the stepmother said, oh, of course I'll take care of your child. But after death, everything changed. And so what that father should have done was he should have set up a trust for, he could take care of his wife, his new wife, and make sure she had funds of her own during her lifetime. But he should have set up a separate trust for Cinderella as well, so that she didn't have control over Cinderella's assets. And so there's bloodline protection. There's also protection for your children if you have a blended family situation. And there's also protection of what you want to happen. So for instance, you're married, you and your spouse built up assets together, but you have separate earnings. Like maybe I have $1 million 401k and I'm going to leave it to my surviving spouse, but I might want to leave it in a trust because if that spouse remarries and then they die, that new person will end up with my money. And so I may not even have children that I want to leave it to, but I might have a niece or a nephew or another family member or a charity. So I can put it in trust and say it can help take care of this person while they're still alive, but they are not going to control where it goes once they die. So after they die, if they have a new spouse, it's not going to go to that new spouse. It's going to go wherever I decided, whether that's my children from a previous marriage, nieces, nephews, cousins, charity. So a trust has a lot of benefits that can protect you. And it also can help you while you're alive and if you're incapacitated. It works similar to a financial power of attorney. And sometimes when you're dealing with banks, it works much better and a smoother transition when there's a trust in place instead of a financial power of attorney. A lot of times you have to jump through more hoops with the legal departments at financial institutions when you're trying to use a power of attorney versus trust. So the trust is very important, and that revocable trust you can change during your lifetime. So when you set up a trust, you are not protecting yourself. So you can't protect from your own creditors when you set up a trust, but your beneficiaries will be protected once you pass away and they benefit from the assets. So while you're alive, when you set up a revocable trust, it's the same as you. It's just that this is telling the public that there's a trust in place and there are beneficiaries who will be protected once I'm gone. Now, an irrevocable trust does protect you. Go ahead, Mavis. I see you raising your hand.
I was going to check in. We have about 8 minutes before we move to the questions and answers section.
Okay. So an irrevocable trust is a way of, it still doesn't protect you from your creditors, but it removes your control. And so that's very important to understand. With a revocable trust, you can change it and you still own the assets. With an irrevocable trust, you cannot change it. And once you put assets in there, they are not considered yours anymore. So they now truly belong to the trustee. And I say truly because with a revocable trust, you typically are your own trustee while you are alive. And then someone else becomes the successor trustee, whether that's your surviving spouse or a child or a other family member or friend. But with an irrevocable trust, you cannot be your own trustee, because the point of an irrevocable trust is to take these assets out of your possession and control. And so you're basically saying, I don't own these anymore because I don't want to be taxed on these assets, or I don't own these anymore because I don't want these assets to be counted as the assets that I own so I can qualify for Medicaid. So I think that's all I'll say about trust. I think there's some questions in the chat. And
yeah, one question had to do with, one question was, should you have both types of trust? And I think it really just depends on your circumstance. I'm not familiar with folks having multiple trusts, but if you are focusing on intergenerational family land, you could have a trust just for that intergenerational family land succession planning, and then for your other assets have a different trust for other reasons. But I think what Pamela's main points were that it's important to have a plan that is suitable for your goals, your circumstances,
yes,
et cetera, right?
That's exactly right. And I do have clients that have both revocable and irrevocable trusts. So it really is, that is a very customized area of planning, and it depends on the circumstances. And a lot of times people can do a simple will and it can look the same as the person's next door. But a trust really is very specialized and customized to that person's specific desires, because you also have to think about how long you want to keep the assets in trust. And that's very, very important. I wanted to mention two things about minors and beneficiary designations. When you leave things in trust to your children, my recommendation is that you leave things in there for their lifetime. A lot of times people want to create a trust that says, okay, we'll let them have everything at the age of 30 because we think they'll be mature by then. or 35. And a lot of times that's right when life is really happening. You could be going through a divorce, could be dealing with some type of lawsuit or different kinds of challenges. So, and when those assets come out of trust, they are no longer protected. So it's best to leave them in trust and let them take assets out as they need them rather than receive an inheritance outright, because then there is no longer creditor protection. So, and then what I wanted to mention about minors is please do not, so that's in conjunction with beneficiary designations. There are assets that are not part of your estate, and those are assets that you designate a beneficiary on, such as life insurance policies and retirement plans, 401ks and IRAs. So when you put these beneficiary designations on these assets, please remember that they are there, and remember to change them if you remarry or if someone predeceases you that you had named. So you want to make sure you change those beneficiary designations as things change, because those are passing by operation of law. They do not go through the probate process unless you did not name a beneficiary, or that beneficiary passed away before you did, and now there's no one there. So if that's the case, then your estate becomes the beneficiary. And this can be quite disastrous because, you know, life insurance policies usually are pretty significant, and so are 401ks. And what now happens if it goes into your estate is you now have created two problems. One, you will pay transfer fees on those. Like I told you, 40 cents on every $100 you transfer. So that money is going to go into your estate, and the court is going to get their percentage of it. But worse, you will also pay taxes because your estate is considered an entity of itself. So it needs its own EIN number, and it files taxes if it makes money. And so if your 401k plan came into your estate, it could be taxed. So, and that is an asset that never would have to go through your estate, but for not naming a beneficiary, or worse, naming a beneficiary, naming the estate as a beneficiary. And I do have an administration case where that happened. Unfortunately, a gentleman named his estate as the beneficiary of his 401k, and when the estate received it, it ended up paying almost half of it in taxes, because what you need to understand is that an estate is taxed at a rate that is much higher than individuals. So for instance, we all know that there are tax rates ranging from 10% up to 37%. So you have to make, depending on your filing status, $400,000 before you're in the highest tax bracket. Well, with a trust, you're at the highest tax bracket with $12,000 of income, approximately. So most, IRAs have much more than that. So there was federal and state taxes on that at the highest rate. So you do not want to name your estate as a beneficiary of anything because of the court fees and the taxes. Now, insurance policies are not taxed, so you wouldn't be taxed on that in the estate, but you would pay the court fees on it. So you want to make sure anything that has a beneficiary designation is properly labeled, and don't ever put your estate. Then the last thing, and then we'll go to questions, is please don't name a minor because as a beneficiary, it happens all too often. But what happens is minors are not able to contract, and they're not able to receive an inheritance. So if you were to name a minor, then that minor will have to have a guardian appointed for the estate, and you will have to account for on an annual basis the money that was used to support that minor. And I have one horror story that I'll tell you, and then I'll end with that, and we can go with questions. I had a lady come to me whose husband had passed maybe 12 or 13 years ago before at the time that she came to me. And he had no will. They had 5 children together, and he had just closed a major real estate deal and was getting $1 million, and then had some emergency thing happen to him and he passed away. Well, so they had $1 million, but he had no will. And so according to intestate succession, when you have 2 or more children, the surviving spouse gets 1/3 and the children get 2/3. So she got approximately $300,000, and the children were splitting $700,000, but all of them were minors. And so therefore, the court had to supervise their earnings. So she had to get appointed as the guardian of the estate of all of her 5 children. They were all her biological children. And she had to report to the court every year until they all turned 18 on how that money was spent, what it was invested in, what earnings it produced, and there were fees on those earnings. And so when she came to me 12 years later, there were still 2 children that hadn't reached the age of 18. So you really don't want to leave anything to a minor, because you now are the biological parent rightfully having custody, but you have to account to the court for how you're supporting that child and how you're using that child's funds, not to mention that they are now going to receive a lot of money at the age of 18, because then the court will release the money. And so she told me a little funny story about one of her children decided, well, I'm not finishing high school because I know I'm going to get about $200,000 when I turn 18, so I'm done. And she said she told him, well, tell me where to send your mail, because you're not going to live here anymore. And so she said she was scared to death, but it actually worked. He stayed in school and finished. But, and he was grateful later, but at the age of 18, it's not really, you know, all of us can think about how we were at the age of 18. And if you come into a large sum of money, I'm not sure we would spend it wisely. So not a good idea to leave things to a minor, because you will have to report to the court how that money is spent, and then they will come into a windfall at a very young age and possibly blow that money. So those are 2 more things that I wanted to mention, and we can go to questions and maybe some other things will come up.
Awesome. Thank you, Pam. Pam and I both want to just express that, you know, there are things that you can do for heirs property and planning that I guess we consider best practices, so to speak. One, it's important to appreciate the history and contributions of family land as heirs property. If you own heirs property, and I own heirs property, I know that it can be very challenging and it can sometimes be overwhelming and even painful, but we can't ignore the significance of the family property in our family's legacy and history. And then it's important to invest in an attorney rather than taking the DIY, the do-it-yourself, or the simple route. So many people that we encounter want to look at deeds or documents that they can get online as a way to get a resolution, particularly because on the front end, it feels more affordable. It seems more affordable. You know, why would you invest in an estate plan that costs $1,000 or more when you could get a deed prepared for $50 or $100? Well, I can tell you, and I'm sure Pam will back me up on this, if you do that, there's going to be there's going to be a high cost down the road. Do it yourself. When folks are generating documents on their own, they're not lawyers. There's even lawyers who don't work in these practice areas. It's very easy to make a mistake. It's very easy to make unintentional transfers, or to include include people you didn't mean to include, or just to not affect anything. And then deeds, you know, folks will often say, well, can't we just quit claim deed it? Folks are often saying QUICK. The legal term is QUIT, and quit claim should not be synonymous with quick. It is quick insofar as attorneys are not responsible for, are often not responsible for confirming the title, that there are no claims on it, but it actually is just the type of warranty that the grantor is making in the deed. It has nothing to do with being easy or facilitating something more simply than trust or a comprehensive estate plan. We also think that it's important to have asset maps. So, you know, find out what the resources are for your property or for your community of heirs property owners, and create a resource that folks can look to when they need to have an appraiser or the surveyor or an attorney. And then we know for organizations on the call, we need funding to support heirs property owners in addressing these legal issues. Now, some of you sent questions in advance. We appreciate that. I do think that our presentations may have answered a lot of your questions, but Pam, I wanted to highlight some of the questions that came through that perhaps we didn't address. One thing, there are a lot of questions when it came to clearing title about, you know, how do you break down lineage? How do you split, how does property get split between heirs? How do you address surviving spouse and children's roles with the property? I will say that when you're thinking about addressing the title issues or confirming who the current owners are, it's important to think about investing in getting a legal opinion of who the current owners are. A deed is not going to fix that. It's not about adding people to a deed. A deed is one transaction. So it's not that you add someone to a deed, you would need another deed, and it doesn't necessarily change in the legal status of the land just because you've created a deed. So deeds are not the answer when it comes to clearing title. Someone also asked about if you have managed the property for more than 20 years, you know, paying the property taxes, can you obtain title to the property? And the answer is it depends. Simply paying the property taxes is not a sufficient action to get ownership in your name. It would require control exclusive to the other owners. So, you know, let's say you're paying the property taxes, but one of the other owners is living on the property. Well, it would be difficult for you to argue that you had control over the property. So it really does depend on the circumstances and what's happening with the land and whether the other owners are aware of what's happening. It's not an automatic, so it does make sense to talk to an attorney about your specific circumstances and whether there's an actionable claim to have title in your name. But it can be worthwhile to explore that, particularly when you know that there are a lot of heirs who have not been engaged with the property. Let's say that there's 70 heirs and only a few people have been engaged and taking care of the property. It may make sense to pursue a quiet title action over trying to clear title and get agreement of the other owners. And then in looking at succession planning, someone asked, what are the best ways to co-own land? I think Pamela did a great job of talking about trust as a way to do that. And then we know other entities such as LLCs are a great way to do it. And someone asked, how do you resolve heirs property that's more than 50 years old? Well, that's many families have had heirs property in their family for more than 50 years. A lot of folks that I've talked to, their family became owners like 100 years ago. So it really does take having that family tree and working with an attorney to confirm who the current legal owners are. Someone asked a question about, you said they would like to discuss property after a death in COVID time. Not really sure what you meant by that. So if you want to put a reframe of that question in the chat box, perhaps we could address it. But I will say that we know that COVID has hit a lot of families and a lot of folks have passed away. The only difference I would say is the amount of people who have suffered from COVID and who have passed away. That might increase the amount of state administration that has to happen for family members in your in your family before you have clear title. Someone asked, what is the best way to transition from an LLC to a multi-generational plan? In our view, an LLC should support a multi-generational plan. It's a tool that is meant to create a multi-generational plan. And then someone asked, how can you make sure all of your properties are listed properly in your estate plan? Pamela, do you want to take that question?
How to make sure what's that?
How should I make sure all of my properties are listed properly in my estate plan?
Yes, well, typically when you go see an attorney, we have questionnaires. So we get a list of all of your assets, and then we can help you determine, that's part of the process of helping you determine your estate plan. It's how you should leave those assets. So one of the requirements is that you understand what assets you have, and that helps us determine that you have the capacity to write a will. So we have the questionnaires that guide you to try to look for, okay, do I have this type of asset? And that's how you can make sure. And then in the sections of the will or the trust, then we can talk about how you want to leave that asset and to whom. So hopefully the questionnaire will help you gather, help trigger your mind as to what your assets are, but you don't necessarily list them all in your documents. You kind of keep them broad, but you do want to have an idea of what assets you have. But typically it's in a more broad category in your documents. Does that help?
Sorry.
You okay, Megan?
Excuse me. Allison, do you still want me to unshare my screen so that you can put the information up?
I also,
No, you don't have to. That's fine. That's fine. You're good.
Okay.
While we're talking, I see another question in the chat, and that reminds me of something that I wanted to say. Someone said, my mother gave me a small house with no taxes or fees before she passed. Can that still be done? I'm not sure what that is that you're talking about, but I do want to make a comment about transferring property, real property, before death versus after death, because that has a tax consequence that I wanted to mention. So there could be reasons why you want to do it, but typically when there's real property, for instance, let's say there's a house and someone bought it for $100,000 and now it's worth $500,000 and you want to give it to your children. Well, excuse me, it's best to wait and give it to them after you pass away. And that is for a tax reason, because everyone has heard of capital gains, and you know that when you sell a home, you pay tax on the gain between what the home is worth now and what you originally paid for it. So in the example that I gave, there's a $400,000 gain. Now, there are exceptions to when it's your primary residence. You can exclude some of that gain, but that's when you're the original owner. When you inherit a property, you get the cost, you get the fair market value basis of the property. So if someone passes away with a $500,000 house, in your hands, it is $500,000. So if you turned around and sold it the next day for $500,000, there would be no gain. However, if they gave you that house before they died, then your basis is $100,000. So they gave you the house, it's worth $500,000, and after they pass away, you want to sell it. So now you will pay taxes on a $400,000 gain, whereas if you had inherited the property instead, you would have no gain. So again, like I said, this is not what you have to do, but you have options, and there may be reasons why you would want to transfer the property while you're still alive. But in most cases, for tax purposes, it's best to let that property transfer at death so that they can get what's called the step up in basis. And so that was just something that I wanted to add. There's another question. Are heirs classified as owners if a lien or mortgage is still due at death and no will is available? Yes.
And I was about to put that answer in there.
Okay.
Pamela, to go back to that last question, in addition to the basis, the transfer also triggers a gift tax depending on how much the transfer was worth. So if it's over, what's the gift tax currently? $15,000.
Yes.
So if the value of the asset transferred is over $15,000, then the new owner has to pay an income tax on that. And that's whether the person is transferring to multiple people or not, is as long as those individual shares are 15 or over, then that's a gift tax implication.
Right. And let me explain a little bit about gift taxes, because you have to file a gift tax return, but there is actually no money that has to be paid at that time. And so what happens is you have an opportunity to transfer assets during your lifetime or at death. And I'm going to try to make this really quick and hopefully simple. A lot of people hear the term death taxes or estate taxes, and people don't like that. That's different from income taxes, which is what we pay every April 15th when we file our taxes. But when you pass away, there could be an estate tax on your assets. That is also different from the tax that I was talking about during my presentation when I said your estate may have to pay tax on assets that come in. That's a different type of tax. That is also an income tax, but it's an income tax on the estate as a separate entity. Now I'm talking about estate taxes, which are different. And so what happens is you can transfer money during your life or at death. And right now, the amount that you can transfer tax-free is over $5 million. That number fluctuates depending on which party is in office and whether they change the laws. And so that number has changed. It's been as low as 600,000. It's been $1 million. It's been 3.5 million. Now it's at over 5 million. So you can transfer that money without paying estate taxes. Now, you could do that either during your lifetime or at death. So when you transfer items during your lifetime that are over a certain amount, because they give you an annual exemption, which is the 15,000 that Mavis was talking about. When you transfer more than $15,000 to one individual, then you have to report that on a gift tax return that says I transferred $200,000 to this person. The government does not collect any tax on that. What they're doing is they're saying, okay, you had the opportunity to transfer over $5 million during your death. So now, during your lifetime or at death. So now we're going to keep a tally. So now you have over 5 million minus the 200,000 that you gave. So it really is a reporting aspect. There is no money that you have to pay, but you have to tell the government, I gave some of this money away while I was alive, so that now my amount that I can give at death has decreased by the amount that I gave away while I was alive. And so they're keeping track of that. And if you end up giving away more than that, then you'll pay tax. So I hope that makes sense.
Yeah. There's one more question that we'll answer before we wrap up. The question is, how long can property remain in the name of the deceased owner? I think it's important to understand that ownership transfers either by deed or by dying. So even if the court records, or the public records rather, do not show the ownership transferring through inheritance, the legal transfer has occurred. However, what we commonly see on the tax records is the name of the deceased owner, and it could be someone who passed away a long time ago. That's because the tax office is relying on what records are available. And if there hasn't been estate administration for deceased family members, then the tax office doesn't have a way of updating their records. You would have to instead reach out to them and explain what has occurred and provide documentation to update the tax records. But tax records are different. Like how the tax office reflects who the owners are is really different from what is required from a legal perspective to demonstrate ownership. But I might have just confused the, the answer, but just suffice it to say, the ownership's changed. It's just the records need to be substantiated and updated. All right, so we'll end there. Alton has shared with you all that we'll make the slides available. And this is also going to be, it's recorded, so the video will also be available. Alton, I'm guessing you have some closing remarks?
Okay, boy, I thank everyone for hanging in there. This is a lot of information that has been bestowed upon you this evening, but it's a very important information that we all need to take into advisement and hopefully move forward. So again, thank you, and thank to Mavis and Pamela for providing their expertise this evening. And as I said, if there is any follow-up, if you missed their contact information or if you lose their contact information, just connect with myself or Sherwin Bess, and we'll get any questions and follow up to them. So with that, I am so glad that we had this opportunity to spend this evening with you. I will say I was a little bit nervous, but you all really hung in there till the end. So that is just fantastic.
Yeah, that's amazing.
Fantastic.
That was amazing.
But please take the survey at the end, because our funders want to know, what we're doing, how we're doing it, and if this information is resonating with you all and the importance of it. So please take that survey. Shouldn't take you but a minute or so, and we would greatly appreciate that. So thank you to Extension Forestry for hosting this for us this evening as a partner. And again, we bid you all a safe, good evening, and stay safe out there and continue to practice your protocols with COVID-19.
Thank you, Alton. Thank you, Roanoke Electric. Y'all are awesome.
Thank you.
Thank you, guys. Thank you. Thanks, Bob. Meg. Thank you all. We'll